The next matter to come before the court this morning is State of Ohio versus Edward L. Green. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, please let me know when you get started. I'm keeping the clock today. The arguments are being live streamed and recorded. Please keep your voice up. Please don't use the names of any victims or children, though I'm not sure in this particular argument that may become relevant. We like to make that admonishment. As I just indicated, these arguments are going to be posted on the court's YouTube channel. The judges have read your briefs. We're ready to proceed when you are. Counsel, would you like to reserve any time for rebuttal?
Your Honor, I'll reserve 5 minutes, but I don't think I'm going to take even the 15 with the rebuttal time, but I'd like to reserve the 5. Thank you.
Thank you. You may proceed.
Thank you. May it please the court. Members of the panel, this is a reasonable doubt case. But for this issue, Mr. Green's case would have been decided by now, hopefully with an acquittal, but instead he's still sitting in jail. I worked on this case day and night, weekend, for months, retained a qualified expert, and we were prepared and ready to go. Then out of nowhere, in close proximity to the trial, this allegation of a conflict of interest is raised. It caught both me and my client off guard. I knew I had represented Mr. Withrow before, and to the best of my recollection, it was in a domestic relations related issue. A search on the docket shows that I represented Mr. Withrow in a probation violation, a domestic violence probation violation. And I was the third, maybe the fourth attorney when I appeared at the change of plea hearing and sentencing in February of 2021. I didn't prep the case. I didn't do discovery. I didn't interview witnesses. I just appeared at a change of plea hearing / sentencing.
Gedrock, does all that appear in the record from the trial court? Was that all put on the record before exactly what your representation of Mr. Withrow was before?
To be 100% honest with you, I'm not sure if I exactly identified. I just knew it was a domestic relations issue because it's left my memory. I was totally surprised. But anyway, that's the answer I can give you. All right, I didn't prep the case. I didn't do interviews or interview witnesses or discovery. I just appeared at a change of plea sentencing hearing. What's interesting to note is the state could have determined this had they looked for themselves. But instead, they raised nebulous, unspecified concerns about what might happen in court were I to cross-examine Mr. Withrow. And I emphasize the word might. But isn't that the role of the judge to determine what can and can't come into court? If the judge thought I was approaching in trying to introduce evidence or testimony that was related to a prior conflict or prior representation, a conflict of interest, she could have shut me down. And if I had continued to try to bring that evidence in, I'd be facing some serious disciplinary issues here. So I think this is an area
doesn't the U.S. Supreme Court case of Wheat, though, say the judge doesn't have to wait until it happens at trial? The judge can proactively say there is a conflict and have disqualification in that circumstances if there fairly is a conflict.
Sure, I agree with your assessment. If there is really a conflict. Okay.
And in your position here is, I take it there's no conflict based upon the waiver signed by the parties.
Correct. Exactly. Had the prosecutor.
I have a question. What is the crux of Mr. Withrow's testimony in the Green case? Is he just a side witness that doesn't have his? What's his role as a witness? Is it more material in the case? What's the crux of it? What would be the crux of his testimony, you believe?
I think he's going to try to suggest, based upon what I recall, that my client was trying to gain access to inappropriate photographs. But that's doubtful because I prepared to cross-examine that and to prove that that didn't happen. Basically, Mr. Withrow was in jail for 24 months and he was looking to get a deal when he came and approached the police and said, hey, I have some information about some phone calls.
Counsel, I'm guessing that part is not in the record about Mr. Withrow's incarceration and seeking
No, that's true. That's
Okay.
true.
So,
With anything proffered to the trial court below about what his testimony would be when she made the decision on disqualification?
I don't recall anybody proffering what his testimony would be, to be honest with you. All right, excuse me. Any more questions? Because I don't want to interrupt somebody if I can. All right. The prosecution hasn't shown that there's been a substantial relationship between the two cases. In State versus Gilliam, we're not dealing with me representing co-defendants, as in the case of State versus Hackney, where I am not representing a material witness against the defendant while I am the defendant's attorney. And like in State versus Johnson, I am not representing a previous confidential informant who was part of the case against my client. I quote these because that's what the prosecutor quoted in their brief. And I want to point out that these are distinctively different from the situation between Mr. Green and Mr. Withrow. In those instances, it was an obvious conflict of interest, but my case does not rise to anywhere near that level. My client has a paramount constitutional right to choose his own attorney. The state's motion alleging a conflict of interest is an extraneous distraction. When I prepared the document the judge commented on, I was trying to be scrupulously honest. I wasn't trying to hide things, misrepresent, misstate. I was being scrupulously honest. I may have misspoken, but my misstatement doesn't change the reality that there's no conflict of interest or that the proof of any has ever been demonstrated. Admittedly, it could have been a little bit more articulate, but my lack of being articulate doesn't relieve the state of the burden of proving the conflict. It's their duty to prove it. It's implicit in any criminal defense. An inability to cross-examine a witness will have a negative impact on the defense. But that issue was resolved when Mr. Withrow signed his waiver. He had no problem with me cross-examining. And then my client signed a waiver explaining that he understood what was going on. So the proof of the conflict of interest that brings us today has never been demonstrated by the state. Instead, all they keep talking about is possibly nebulous, unspecified, maybe possibilities, but no proof. And I'll just save the rest of my time for rebuttal. Thank you.
Mr. Gedra, quick question. Was there any discussion about having another attorney involved in the case to cross-examine this witness only? Mr. Withrow?
Well, that never came up, and I don't think that was even put on the table because as soon as they brought up the argument with Withrow, I was basically disqualified. But that's a possibility that it could have been brought up, but was never even considered by even the court, the prosecution, or myself.
Thank you, Mr.
I'm sorry, I don't mean to interrupt you, but Mr. Green has a lot of faith in me and a lot of faith in my case. And I don't know how he would have felt, to be honest with you, having somebody else come in who didn't know the case as well as I did to even take part in this case. Thank you again.
thank you, Mr. Goodruck. You'll have the full 5 minutes for rebuttal.
Thank you.
Morning, Your Honors.
Good morning.
I'm Vince Felucci with the Medina County Prosecutor's Office on behalf of the appellee of the state of Ohio. Your Honors, Mr. Gedrock's former client, Jeff Withrow, who he previously represented in a criminal case, was one of the state of Ohio's major witnesses in the case against Mr. Green, who Mr. Gedrock also represented. I might even call him the star witness in the case. Basically, Mr. Withrow had done some jail time with Mr. Green, and Mr. Green told Mr. Withrow.
On that point, is that on the record that he's the star witness or anything about what his testimony would be? Because there must be a showing of an actual conflict. So where is that in the record, or what is that on the record?
I will say a lot of this happened back in chambers, Your Honors, a lot of these discussions. In terms of the actual transcript before this court, you're not going to see anything about this. This guy's our star witness. And this is what he's going to say. That is true. But Mr. Withrow did some jail time with Mr. Green. And to answer this court's question, Mr. Green told Mr. Withrow some very incriminating things. Mr. Green confessed to Mr. Withrow to possessing 3 photographs of a nude 10-year-old female.
Well, I just want to make sure, please limit yourself to what's in the record before us. I don't want to hear what was in that's all we can look at. We can only look at the record, the hearing where, the hearing was held, X, Y, and Z was said. So for both of you saying, this is from this type of a case, it's from that type of a case. If it's not on the record, we're not gonna be able to review that. So.
Understood.
If that's in the record, fine, but I'm just curious if it's in the record.
The waiver that Mr. Gedrock asked Mr. Green to sign in this case was correct in stating that there was a substantial risk that Mr. Gedrock's ability to consider, recommend, or carry out the appropriate course of action for Mr. Green was compromised. And that certainly is in the record. The court below did not abuse its discretion when it rejected that waiver and disqualified Mr. Gedrock. Conflict of interest could not be more clear in this case. The Ohio courts, the federal courts have all often recognized the obvious potential for conflict where defense counsel is on the one hand under a duty to zealously represent their current client, but on the other hand has a duty of confidentiality to a former client who's a government witness. That's exactly what the trial court was faced with in this case. And that conflict, that potential for conflict at the very least, comes especially in the context of cross-examination. Because defense counsel's most important function in a criminal trial is to vigorously cross-examine the government's witnesses. Defendants have no right to an attorney with a conflict of interest. And all that's required under this court's case law is that the interest of the current defendant potentially conflicts with the interest of the attorney's former client. An attorney who has to cross-examine a former client in a case inherently faces divided loyalties. On the one hand, the risk of competence is coming to light in the cross-examination of Mr. Withrow would be high, while at the same time, the risk of Mr. Gedrock holding back in some way in his cross-examination to avoid that happening would be high for Mr. Green. It's a classic no-win situation for both the current and the former client. It's a situation that the rules of professional conduct and case law say in no uncertain terms should be avoided at all costs. And even the appearance of a conflict of interest, Your Honors, could easily lead to later questions about the fairness of the proceedings against Mr. Green. Mr. Gedrock has argued standing as well, but I do want to mention that, but the standing issue only arises in the civil and not the criminal arena. That's why there's only been civil cases cited on that. None of the conflict of interest law in the criminal context holds that the state lacks standing to assert it. In fact, that's the only way that it can be raised in most cases, because the court would have had no idea that Mr. Gedrock represented Mr. Withrow. The state had to assert it. Mr. Gedrock's argument has been that the concern only applies if he was actually unable to cross-examine Mr. Withrow. But any risk at all of Mr. Gedrock not being able to cross-examine one of the prosecution's key witnesses is in itself a significant disadvantage to Mr. Green, and any other attorney in the world would not create for Mr. Green. And of course, that's not even mentioning the risk of Mr. Gedrock having to hold back in some way in his cross because something came up that triggered his duty to Mr. Withrow as a former client. At first, Mr. Gedrock didn't even know representing Mr. Withrow.
Counsel, the exhibit in this case signed by the witness, the former client, says that there is no confidential information or attorney-client privilege information for my case with Attorney Gedrock can be used against me by Attorney Gedrock in Mr. Green's case. So wouldn't that acknowledgement by the former client indicate there is no problem with cross-examination here?
That he's thinking of at that moment, and essentially what what a lot of that was an agreement between Mr. Gedrock and Mr. Withrow on what the cross-examination would look like, which in itself, I would note, is a significant disadvantage to his current client, Mr. Green, that he's engaging in an agreement with the government's key witness on how he's going to cross-examine him. And
That's not what the informed consent waiver says. He says he knows this because I've been interviewed and briefed by the prosecution. He doesn't say I know this because I talked to Mr. Gedrock. Mr. Gedrock said to me, hey, I'm not going to ask you about A, B, and C. So he's saying this is what, based upon talking to you, he knows there's no confidential information or attorney-client privilege information. It's the problem in this case.
he doesn't think so now. As I was just about to say, though, when this whole thing started, Mr. Gedrock didn't remember representing Mr. Withrow at all. Later, he remembers all these things that he just told you at the beginning. He said, "Oh, it was a domestic violence case. It was a probation violation." All this detail comes back to him later. What's to say that more detail is going to come back to him later, or even during the cross-examination, as this case plays out? There is a very high potential for conflict occurring here. It's something that's going to prejudice Mr. Green in his case. And even if not, there is an appearance problem that can potentially lead to problems down the line in this case. What else is he going to remember about Mr. Withrow down the line in terms of conversations they might have had off the record? I know he says this was a fairly quick hearing on the record. That's what he remembers now. Like I said, that is his recollection has changed over time of this. And the safe thing to do is to get him off the case, to disqualify him, which the trial court was well within its broad discretion to do. And that's what it did. If there are no other questions, I would just respectfully ask this court to affirm the judgment of the trial court. Thank you.
Thank you, counsel. Attorney Gedrock, you have 5 minutes for rebuttal.
Thank you, may it please the court. I'd like to correct something. I didn't suddenly remember. I have consistently said that I didn't remember what I had done for Mr. Withrow because it was not of consequence to this case. I knew it was a domestic related and not related to charges here. I did a docket search to find out what I had done for Mr. Withrow. So it wasn't a sudden remembrance. And it's not like I'm going to suddenly remember more things. My position is consistent that I am going to only cross-examine Mr. Withrow on what I have uncovered as a result of my investigation and my preparation for Mr. Green. That's been my position from the beginning and throughout. It hasn't changed, okay? The claim of the alleged conflict of interest is an attempt by the prosecution to deny my client effective representation. They're trying to get the attorney who knows the case inside and out of the case. And why did they wait until within striking distance of the trial to do that if this was such a big concern? We hired an expert who's reviewed the testimony of their experts and was prepared to testify. I'm not saying the state was malicious in trying to get the attorney who knows the case better than anyone off of the case. But that puts Mr. Green in a position where he has to go to trial without an attorney who's not his first choice and may not be as committed to the case as his current attorney. The right of counsel to one's choosing is paramount and should only be denied under extreme circumstances, and they don't exist here. A mere allegation, speculation, conjecture, maybe this, maybe that is not evidence. That's not enough. The motion by the state to disqualify me was made in bad faith. They never proved a substantial relation to the present case that I must have acquired confidential information. That was never proven. Substantial relation or that I must have acquired confidential information. The court can't encourage such actions. Otherwise, the prosecution can do it to anyone, anytime they want to diminish the level of opposition. Proof, not unsubstantiated allegation, is what is required. And they know that. And that's why they can't offer anything other than unsubstantiated allegations. There's no proof. Mr. Withrow signed a release, waiver. My client signed a waiver. Everybody involved in this case has a clear understanding of what is at risk and what is going on. And again, if I have to be disqualified, I have to be disqualified based on proof, not speculation and conjecture. And I want to make one more point, and then I'll wrap up. Mr. Withrow, who knew I had represented him in the past, recommended me to Mr. Green. He encouraged me to take Mr. Green's case. That's how this all got started. Thank you for your time.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision in due course, which will be mailed to all parties to this appeal by the clerk of courts, as well as posted on the Ohio Supreme Court website. Again, thank you, gentlemen, and thank you for agreeing to appear via Zoom.
Thank you, Honor.
Have a good day.